and we'll get going. Thank you. Good morning, everyone, and welcome to the Criminal Justice and Public Safety Committee. We have 3 bills today that we're going to have a public hearing on, and we're going to take them in the following order: 539, 573, and 546. And we're going to start with introductions, and I'll start with Senator Searway.
Good morning. I'm Senator Scott Searway, and I represent District 16, which covers Waterville, Winslow, Fairfield, Benton, Albion, and Clinton, and Unity Township.
Thank you, Senator. How about Representative Costain?
Good morning. Dan Costain, District 100, which I represent, part of Etna, Dixmont, Newport, Plymouth, and Corona.
Great. Representative Rudnicki.
Good morning. I represent House District 108, which is Fairfield, Mercer, and Smithfield. And I'd just like to say, again, I think we're doing a disservice. I'm here at the Capitol, and I'd like to ask a question as to why we are bothering to do this today and Monday if we're shutting down next week.
Thank you, Representative. Representative Lookner.
Morning, I'm Grayson Lookner here in Portland, District 37, neighborhoods of Rosemont, Libbytown, Stroudwater, and Nason's Corner, not necessarily in that order.
Representative Pickett. Oh, whoops. Representative, you're on mute.
Okay, somebody in. Okay, my name is Dick Pickett. I represent House District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru.
Thank you. Representative Pluker.
Thank you. I am Bill Pluker. I represent House District 95, which is Warren, Hope, Appleton, and part of Union. Thank you very much.
Representative Newman.
Yes, good morning. My name is Dan Newman, District 76, which is Belgrade, Rome, Mount Vernon, Fayette, Vienna, and Wayne.
Thank you. And I'm Representative Charlotte Warren. I represent the city of Hollowell and the towns of West Gardner and Manchester. And I want to introduce and thanks our committee staff. We have Jane Orbiton, our committee analyst, and we have Deb Fay, our committee clerk. So thank you both for being part of the team. Okay, so I know that our Senator DeChambeau, is starting her work today on the Government Oversight Committee. So that's where she'll be for a part of today, if not most of today. And I know others are in other committee rooms, so we'll see them soon. Again, I'll just re-announce the order that we'll take the bills today. We're going to start with LD 539. Next, we'll go to LD 573. And then finally, we'll take LD 546. So I see Senator Marymount is here. Good morning. And this first bill is 539, an act to require law enforcement agencies to do a thorough background check of applicant officers and to require the release of records, including sealed records, to the requesting agency. And I think it's best if those who are here planning to testify on this bill, is this the right time, Deb? Or after the senator?
Yeah, let's wait till after the senator.
Thank you. Good morning, Senator.
Good morning. All right, I'll jump in.
Great.
You've already read the title, so good morning. I don't see Senator DeChambeau yet, and Representative Warren, members of the Criminal Justice and Public Safety Committee. I'm Dave Marymount. Proudly represent all the people of Appleton, Camden, Creehaven, Cushing, Friendship, Hope, Idaho, Matinicus, Muscle Ridge Islands, North Haven, Owl's Head, Rockland, Rockport, South Thomaston, St. George, Thomaston, Union, Vinyl Haven, and Warren in the Maine Senate. And I come before you today to present LD 539. I've heard from some different sources about situations where police officers who have a history of brutality or some other improper behavior are not reprimanded But when some action or actions finally result in the employer trying to remove the officer, it's done under the cover of a non-disclosure agreement. This seals the record so that the officer can move to another department without the bad deeds being discovered. When that officer is applying for a new job, he or she does not reveal the former problems, and the previous department has its hands tied by the non-disclosure agreement. This results in a continuation of the behavior in a new position until the story repeats itself. Unfortunately, one of the reasons we know this is that in some cases, the behavior escalates until a serious incident occurs and the whole history comes out. We saw that on some big high-profile cases across the country over this past year. And there were articles on this in national publications. Although it's assumed that the hiring department will do a thorough background check, sometimes it is not done. This bill requires that background check, and it removes any liability from the department where the officer formerly worked when they give the required information to determine the character of the officer. This bill should help stop any officer from being allowed to continue in their position after betraying the trust of the people they are supposed to serve. The elimination of bad officers is a win for everyone. And where the disconnect can come is that maybe someone friendly to the officer at the department they're coming from did the disciplinary action with the non-disclosure as kind of a favor, whereas someone else in the department would have no such compunction based on that behavior and would want to say something to a department that was potentially going to hire the person, but really felt their hands were tied. So it's not universal across the station. So this gives them a tool. It requires the new or the department where the officer is applying to actually perform the check, because we read that sometimes they just don't. They call one source and that's it. So the thorough is the operative word in this background check. And I actually have found the same thing in my businesses over the years, where I would go to check a reference that someone had put down and they just didn't think you were going to follow up on it, because you call the owner of the previous business and they say, he gave me as a reference. And I said, yeah, I wrote it down. He said, I can't believe it. He was like the worst employee ever. But that was years ago, before people dared to say that. Now they would hold their tongue a little more and just be glad that the person was gone. So I know this goes on in other businesses. It's just so critical that it's not going on here. So that's the impetus of this bill, along with some requests by people in the community, but I fully support it. And thank you for your consideration. I'm glad to answer any questions if I can.
Thank you, Senator. So we'll open it up for questions. Senator Searway.
Thank you, Madam Chair. Good morning.
Good morning.
How you doing, Senator? What do you think would be a good way to make it just equal grounds? Like, I know I've experienced this even in schools, so I wonder if we could have maybe Jane just look up what would make it equal all across the board instead of just picking on law enforcement officers. I think even on education, I think they came up with something, and if we could reflect to that, would that be acceptable? Something equal ground?
Yes, thank you, Senator. Great question. I just don't know, with all the different jurisdictions and sections of statute, if we can do that. But if we can, that would be wonderful, to just make sure we're looking at the credentials and history of everyone who has an effect on, well, even their coworkers, but certainly our children and certainly our public through the powers that we give to police officers. But it just sounds like a bigger scope than my bill could do, but there are people smarter than me out there to figure this stuff out. So thank you.
You're welcome.
Representative Pickett.
Yes, thank you, Madam Chair. Thank you for being here, Senator, this morning. I was trying to get set up here, listening to your testimony and stuff. And I guess the question I would have for you, you talked a lot about you're aware of many times, many people not asking the right questions, not doing what they should do to get to the background of an officer who's looking to get employed. Is that information you received personally by reaching out to law enforcement agencies within the state of Maine, or is that just reading the information you talked about the national level of what we all know is going on throughout the United States? Because I think we need to really dig down into where are we in Maine, what are we doing in Maine, and if there is something wrong, then we have to take and go and fix it. I agree, but we got to be careful to measure it on what's happening in Maine and not let the emotion from the others outside come in to cause us to do something in Maine that may not be a problem. I'm not saying it isn't, I'm saying may not be. So I just wondered what your comments might be on that.
Yes, thank you, Representative. What I like about this bill is that it doesn't create a negative on anyone. It just, the part of it says, do what you're supposed to do. And if there's no agency in Maine that isn't, great, it's neutral and it doesn't hurt anything. And I did read of officers being tied, but again, national, and I'm not saying that's a direct reflection, but that in a couple of the articles, the people that were contacted were having to bite their tongue, the former departments, because they had information, but they knew it was in this non-disclosure and they would be liable if it was revealed. So I was naively, when I first moved to Maine, thought, what a wonderful place. It's not like the South. And I came here right after high school. So I grew up on an Air Force base with people of color, and we interacted as if there was no difference. So I believed I wasn't racist, and I believed that the culture wasn't racist in the North. And boy, did I have quite an education still to go regarding that when I started hearing folks talk about what's kind of underground but endemic to a culture. And so I think maybe Maine is better in many, many ways, but if we stopped even one officer whose behavior could escalate because this was in place, it would be worth the few lines of paper that it would add, a few lines of ink that it would add to a piece of paper in our statute. And if it wasn't needed, it would just sit there, but it'd be ready to try to be a buffer. I guess that's the way I look at it. But yeah, I didn't save those articles. They became part of a broader consciousness about there's a problem here if people can jump away from a department to escape disciplinary behavior and go into another place and pick up where they left off. That's all. Thank you.
Other questions for Senator Miramont?
Follow up, please, before you move on.
Yes, please.
Thank you very much. Are you aware, Senator, that there are a couple of bills in the legislature right now? One that is dealing with issues like that. They're dealing directly to sheriffs, but they're dealing with the Board of Trustees and what they have for things that they can do for the oversight and all those kind of things. So I would just point you to check on those and see if maybe some of those might help you as well as what you're trying to accomplish here. Thank you very much.
Thank you, Representative. And I have one of those bills, and I look forward to that discussion with you. I tried to have it a little bit before putting in the bills so that I could refine them a bit, but the committee always helps with that too. So I look forward to continuing the conversation.
Thank you, sir.
Thank you.
Any other questions for Senator Miramont? Seeing none, thank you, Senator.
Thank you.
I'll now ask anyone that's here that wishes to testify on this bill, LD 539, please raise your hand and Ms. Fay will move you over. Great. So I see DA Maloney here to testify. I should have asked, excuse me. We're going to start with folks who are in favor of the bill. And I see DA Maloney, you're on the list and you are in favor. So good morning. Welcome.
Good morning. Thank you, Representative Warren and Senator DeShambo and honorable members of the Criminal Justice Committee. My name is Megan Maloney. I'm the District Attorney for Kennebec and Somerset counties, and also the President of the Maine Prosecutors Association. You received testimony from the Maine Prosecutors Association written by District Attorney Todd Collins from Aroostook County in support of both LD 539 and LD 573. He wasn't able to be with you this morning, and so I'm here instead of District Attorney Todd Collins. So the bottom line of the testimony that DA Collins submitted is that we have a constitutional obligation to give all information that is potentially exculpatory to the defense. And we can't give that information if we don't know about it. So what we want to do is to have all of the information so that we can then give it to the court and to the defense in case it's relevant in a pending criminal trial. With both of these pieces of legislation, it makes sure that if something negative happens in an officer's career, that information is preserved and that information is shared with the court and with defense counsel in case it could be exculpatory. And that's just critically important. We have been here before and you've helped us before. Back in 2013, we asked for access to these records, and it was the legislature that then enabled us to have access to these employment records so that we could see if there was any potential, what we call Brady-Giglio issue, which are two Supreme Court cases, if there were any potential issues that needed to be given to defense or to the and to the court. So we appreciate that assistance, and this is just another step in making sure that all of that information stays with the officer because the defense is entitled to the information. I'm happy to answer any questions.
Thank you, DA Maloney. Any questions? I saw Representative Pickett and then Representative Searway.
Yes, thank you, Madam Chair. Thank you for the opportunity to talk with you this morning, ma'am. I heard what you were talking about, the constitutional obligation to provide information. I understand that. But I found it that you said something interesting to me, which I want to dig down a little bit on. You said you already have, the legislature already helped you at one point to already have access to the material. So I guess what I need to understand from you, ma'am, is what do you need more than access? Are you saying you need to have something written, or is the access before that you didn't have anything written? Or it seems to me that access to the material to make decisions and things when you're doing a case would be the key point. So can you really help me get my head around
Yes.
that and understand the difference, please?
Yes, I appreciate the opportunity to clarify. If information is in an officer's employment file, the prosecutor is now given that information to present to defense and the court in a pending criminal case. The difficulty is that information is not in the officer's employment file if the officer leaves employment and goes to another agency. That new agency may not have that information. If the agency doesn't have the information, then I don't get the information, then the defense doesn't get the information. So it's, it is information the defense is entitled to. Now, as prosecutors, we are not certain as to the mechanics of the best way to transfer this information. So in DA Collins' letter, he does ask the committee to really be to look to law enforcement for the nuts and bolts of how to accomplish these goals, because they will best understand the practical implications of how to make sure the information stays with the person. But that's essentially what we're asking, is that if the information stays with the officer wherever he works or wherever she works, then when I send out my yearly letters asking for all Brady Giglio information and for any follow-up that occurs over the course of that year, I'll get the information. And law enforcement is great about responding. It's just sometimes, as we've been reading in the paper lately, the prosecutor doesn't have the information because the new employment agency didn't receive the information. And that's what these bills are designed to correct.
Follow up, please.
Yes, please.
So if I'm understanding you right, then you ask for the information in the record, but if the officer now has moved to another agency and something's been brought to your attention that may have happened in the prior agency, that are you saying that when somebody leaves a law enforcement agency that their personnel files should move with them to the new hiring agency?
Correct. Yes.
And so what would stop you from being able to contact the prior agency that had the officer with the personnel file still there with them and has access to it, did the investigation, did all of the stuff that has taken place in it, and had that there? Wouldn't you still have access to that?
Well, I don't follow officers' careers. So like if someone leaves a law enforcement agency in my district, I don't know if they get hired in someone else's district. I wouldn't even know. I actually wouldn't even know that they left the agency in my district, because there's too many law enforcement officers for me to track where everyone is going. I also only get information so I'll get all of the information that's related to the Brady Giglio, that letters that I ask for. If an officer leaves and that what is in his or her file doesn't go with him or her and goes to another jurisdiction, there's no reason for the DA in that area to think that an officer with a new hire could potentially have Brady Giglio information unless the chief tells him or her about it. And there's really no way for me to sort of follow the thousands of people who work and where they're going and making sure that what I know is following them. And that's exactly what just the easiest way is for the officer to just keep the information with them, which is our understanding of what the bills are designed to do, is where the officer, that way you're not relying on, me to say, oh, I just see this person moved, they went to District 7, I better call District 7. That's not going to work as a system. You want the information to just stay with the officer.
Okay, thank you. And I think it could work, but that's for a work session. I'll look forward to digging down deeper at the work session. Thank you.
Thank you.
Senator Searway.
Thank you, Madam Chair, and good morning.
Good morning.
How you been? Good?
Good.
Great. I kind of brought this up at first. Seems like a lot of bills are focused against police this year, and so I'm concerned that this isn't more the criminal code. When they make a law, it's usually in general terms of the instances or the crimes, or the broad part of it. And so this is kind of focused on police, but when I was in high school, I can remember a teacher having an affair with a student, and because it got hidden, and then it went to another school and got another job, and it's very similar to what you're talking about here. So what I'm saying is, how can we make this a general thing overall rather than just focused on police? Because to me, we're making it so focused on police that they're looking like the bad guys here, and they're really trying to do a good job. And I think that if we can make it, if there's a way to make a general law to cover what you're saying, I think it would be more constructive. That's what I'm saying. Because police are feeling that now. They're feeling like they're being focused on.
So I definitely don't see the bill as against law enforcement. I see it as actually really supporting law enforcement, because the biggest thing that I hear from law enforcement is that they get lumped in whenever somebody else does something wrong. And we have phenomenal officers in Maine, and they want people to know that they're phenomenal, and they just don't want there to be any question that the work that they're doing and their whole past history is excellent. So from what I hear is this is really a bill that just makes sure that the few officers that have been found to have Brady Giglio issues, which the number is very, very small in Maine, but they make the newspaper, right? Those are the ones that are sensationalized. And so we want to make sure that those few officers aren't giving a bad reputation to everybody else. And this really does make sure that that happens. It makes sure that we know for certain that the officers, the full background of the officers who are investigating and testifying have an employment history that isn't hiding anything. I agree with you, Senator Searway, that there certainly could be, that there certainly is a public trust with teachers as well. I do think it would be a different section of the code because everyone has, the code writes about law enforcement in one section and teachers in another section. But certainly we want to make sure that all of our public officials are people who are upholding what they're supposed to be doing for the public. So this is one step in the right direction, and we could certainly look at taking other steps as well.
And just
So we're
follow
going
up-
to have, excuse me, one
follow
second.
up on that.
Senator, 1 second.
Yep.
We're going to have a lot of opportunity to work this bill. So I just want to remind people that this morning is a time for clarifying questions. So Senator, do you have a question?
Yes.
Please
Yes.
go ahead.
I was just wondering if you could bring to session to have a verbiage that would be equal on the educational and law enforcement, because I think both are as important.
I don't know where it would go in the statute for teachers, because I'm not familiar with that part of the statute. So I'm not the best person for that piece. I think the education committee might. I know that the clerks that you work with are phenomenal, and I would think that perhaps the education committee clerk might know where it would go in the statute, because I don't know where to start.
Thank you.
Yeah, sorry.
Representative Costain.
Thank you, Madam Chair. Attorney Malone, my question would be, I don't see in this bill where we're talking about Giglio. I know what the Giglio law is, but I don't see where this bill has anything to do with that. My understanding of the bill is that it's so if an officer moves from one agency to the other, that if there's anything that they've done discipline-wise, it follows them. Is that correct, or am I missing something on the Giglio on this?
So for example, discipline could result from an officer lying on his or her timesheet. If that happens, that's purely an employment issue, right? You're not going to be charged with a crime for lying on your timesheet, but it is an act of dishonesty that needs to be told to defense counsel, because the officer will be asked about that on the witness stand. Have you ever lied on an official timesheet? That's a fair question to be asked in a jury trial, for the jury to be assessing the word of the officer versus the word of whoever else is testifying in the trial. So that's an example of what would follow, information that would follow the officer from one agency to another.
Thank you. A follow-up, Representative, and this is just for my own knowledge. Does Giglio apply to civil cases testifying like, or traffic infractions as well? Or is it only on crimes?
I believe it's only on crimes. That's when I deal with it, but I'm not, my office no longer participates in traffic court. If it was a civil violation that my office is handling, then I would give the information to the judge. We do handle like dangerous dogs. We handle those. So we do handle some civil violations still. Traffic infractions, we typically are not involved in. So we wouldn't even be in the court to be able to convey information.
Thank you.
Other questions for DA Maloney? Seeing none, thank you for being here to testify.
Thank you. And
Others-
I won't return for 573 since it's very similar.
Okay, thank you. Will someone from the Maine Prosecutors Association be available for the work session?
Oh, yes, I can definitely be available.
Thank you. That would be wonderful.
Great.
Thank you.
Thank you.
Others here to testify in support of LD 539? I see Ms. Collins is here. Ms. Collins, are you here to testify in support? Anyone here to testify in opposition to LD 539?
Sorry, Representative, I was kind of slow in coming on.
Okay.
I'm here not from MPAC. MPAC has not taken a position on this bill. I'm here as a citizen and a member of the Board of Visitors for Franklin County. My greetings to yourself, Representative, and all the members of the committee. I am speaking extemporaneously because I couldn't control myself, so here I am. I know there's a lot of concern with law enforcement here, and as a member of the Board of Visitors in Franklin County, we spoke with our sheriff about the series that Bangor Daily News did, revealing the role that employment files have and how constrained they are in terms of passing that information on to the next whatever, sheriff's department or local police department. And what the sheriff told us, and I don't know if he would still stand by this, but this was only 2 months ago, he said he would welcome a bill like this. And the reason why he would welcome it is when you get a bad officer, no matter who that person is, he or she or whatever, they become a real headache for the department because you have to, document everything. You have to go through personnel procedures. You have to go through, and he said, we just don't want to get somebody's bad egg. We don't want them. So he, in his personal opinion, would love to have this type of law just so that the bad eggs don't keep being passed around and being a headache for every department that they come to. Like the Senator Searway, has mentioned, as a teacher, I always hated it when there was a bad egg in our department and it seemed like there was no way to get rid of them, you know? There's just no way to get rid of them. And they were a reflection on all of us. It made all teachers look bad. So I would welcome that no matter what department we were talking about, whether we were talking about education or health or criminal justice, just think it's a good idea to have some kind of way of moving those people out that shouldn't be in the profession, whatever it is. So personally, I think this has some really good parts to it. That is that it protects everything except for those discipline issues from being passed on. You can't get health information. You can't get other information that's not pertinent to your employment. So that is a part of this bill that I like, and I would hope that any bill, whether it's this one or the next one, includes some kind of protection for the employee, that it really only talks about those discipline issues that are specific to the position. So I thank you all for allowing me to speak today extemporaneously and kind of off the cuff. And I hope that everyone notices that today in the Bangor Daily News, there is an article about an issue with the Millinocket police chief that has absolute pertinence to this bill. Thank you.
Thank you, Ms. Collins. Any questions for Ms. Collins? See none. Thank you. Others here to testify in support of LD 539? Seeing no one, I'll now take testimony in opposition to LD 539. Seeing none, I'll now move to testimony neither for nor against. Good morning, Ms. Graham.
Good morning, Representative Warren and distinguished members of the Criminal Justice and Public Safety Committee. My name is Rebecca Graham, and I'm here testifying neither for nor against LD 539 on behalf of MMA at the direction of our 70-member Legislative Policy Committee. Municipal officials don't have any opinion on the attempts to clarify the existing employment practices, but would point out that in some communities, municipal officers and elected officials often have the final say on law enforcement employment matters with recommendations from the police department and not specifically that law enforcement agency. And employment records are often held in accordance to those municipal authorities and not with that individual agency as well. So there may be some structural pieces there. Waivers are generally already part of that recruitment process and standard in most communities, and they do allow that recruiting agency access to those records with the permission of that candidate in full disclosure as well. While such cases are rare, it is important for this committee to consider why records are sealed and who they are sealed on behalf, and try to make sure that that does not become part of something that becomes public disclosure like the rest of a disciplinary record. There are very few laws that we have that actually protect victims, and that includes complainants who are involved in these situations. And there are several places where that can actually cross over into employment law. We don't want to remove protections for those individuals where the disclosure of their name may also endanger their current working environment or make it challenging for them to find employment elsewhere if that were broadly known or disclosed in a public setting. So with that, I'm happy to answer any questions or be here for the work session with maybe some scenarios of how the recruitment process works. Additionally, actually, I'm sorry, we would ask that you actually consider how to broaden this to provide a similar review for elected law enforcement as well.
Thank you, Ms. Graham. Questions for Ms. Graham? My question is, I know you all provide MMA trainings for municipal officials because I've attended a few of those. If you have anything, I remember getting a binder, you know, that gave me a lot of great material. If you had anything like that specific to HR agreements around law enforcement, et cetera, that you could share with the committee even before the work session or at the work session. I think that'll help us as we dig into this work together.
Absolutely, I'd be happy to do that.
Thank you for that. Seeing no more questions, thank you for your testimony. We also have Ms. Bissell here to testify neither for nor against. Good morning.
Good morning, Representative Warren and members of the Committee on Criminal Justice and Public Safety. I am Brina Bissell, Director of Maine's Bureau of Human Resources, and I'm here to testify on behalf of the administration, neither for nor against LD 539. And I also have testimony that's very similar on LD 573. LD 539 would require applicants for law enforcement positions who work or previously worked in law enforcement to sign a waiver authorizing their current or prior employers to release all performance-related employment records to the hiring agency. The bill would provide immunity to the current or prior employers for providing these records. It would also require the hiring agency to thoroughly review the records and would prohibit the hiring of an applicant who refuses to sign the waiver. I'd like to make a few suggestions and comments about LD 539. First, the bill provides for an applicant to sign a waiver of the applicant's confidentiality rights. It is not clear whether the covered employment records would include pre-employment information, such as applications, letters of reference, working papers, examinations, as well as polygraphs, criminal background checks, and psychological evaluations. Pursuant to Title V, Section 7070, subsection 1, this information pertaining to state employees is confidential, even to the applicant. So because the employee is not entitled to this information, the employee does not have the authority to waive its release. If the bill is intended to include these confidential records identified in Title V, Section 7070, subsection 1, then notwithstanding language would need to be added to it to specifically allow the release of these records by the previous agency. In addition, we would also suggest that the bill be clarified to ensure that the employee will not be provided access to this confidential information. Second, the bill provides that the law enforcement agency providing the records subject to the waiver is immune from liability for doing so, but there's no similar immunity for the hiring agency for receiving the information and using it to make hiring decisions. Third, it should be recognized that this bill would add another step in the hiring process for state of Maine law enforcement agencies, requiring additional time for human resource staff, which will extend the time it takes to hire essential law enforcement officers. I would also note that the bill does not prescribe a time frame for the current or former employing agency to provide the information to a hiring agency, which could further add to the delay. Thank you for allowing me to testify today and provide you with these comments about LD 539. Thank you.
Good timing. Thank you, Ms. Bissell. Your submitted testimony is going to be very helpful to us. I see it's in there. Thank you for that. You'll be here at the work session?
I can be at the work session, yes.
That would be great. Thank you. Questions for Ms. Bissell? Seeing none, thank you. Anyone else here to testify neither for nor against LD 539? Seeing none, I'll close the public hearing on LD 539. And we will move next to LD 573. And I know that Representative Corey is with us. So Deb, I'll give you time to get ready and move him over.
Thank you. Bye.
Thank you, Senator. Thank you. Have a good day.
You too.
Thank you. Good morning, Representative.
Good morning. So I wish I was seeing you all in person. I would have brought treats, right? Because that's what we're supposed to do since I used to be on the committee. I am looking around my table right now and I noticed my wife left these on the table. So if y'all would like me to share, I can do that. This isn't a prop or anything. This is what I have for everybody right now.
Representative Corey, you could just come back. Just come back and join us. Who cares about that stinking AFA committee? Come on.
No kidding. No kidding. I think there'd be less stress.
Yeah, I bet. Well, welcome. Thank you for being here.
Okay, so let me begin. Senator Deschambault, Representative Warren, and members of the Joint Standing Committee on Criminal Justice and Public Safety, the greatest committee in the legislature. My name is Representative Patrick Corey, and I serve the people of Wyndham. I'm here to present and speak in support of LD 573, an act concerning records of the employment of law enforcement officers and corrections officers. Cumberland County Sheriff Kevin Joyce has asked me to sponsor this bill, but unfortunately he isn't able to provide testimony today due to a previous commitment. Sheriff Joyce is one of the 21 commissioners appointed to the Commission on Accreditation of Law Enforcement Agencies, otherwise known as the CALEA, which is a voluntary accreditation program that is based on national standards. The CALEA organization, maybe they say CALEA, meets triannually, and today he is involved in hearings on the accreditation or re-accreditation of law enforcement agencies, thus his unavailability. Sheriff Joyce is available to provide testimony if approved prior to the work session on this bill. I'm hoping that that accommodation can be made. The intent of LD 573, an act concerning records of employment of law enforcement officers and correction officers, is to allow the communication between law enforcement executives who have knowledge of potential criminal activity or activity inconsistent with what is expected of someone within the law enforcement profession by law enforcement officers or corrections officers without fear of civil litigation because of sharing the information. Currently, if a law enforcement officer or corrections officer employed by one agency is being considered for a position in another agency, and during the background investigation or polygraph exam, potential criminal activity or inappropriate activity is uncovered on that applicant, the chief or sheriff cannot share that information with the candidate's current law enforcement executive without fear of civil litigation for sharing that information. For instance, police officer A, who is currently working for a police department, decides to apply for a job at another law enforcement agency. During the hiring process, a background investigation and polygraph investigation will likely be done. And if police officer A is involved in an activity that is potentially criminal or inconsistent with that expected of law enforcement officers, the hiring chief cannot reveal the information learned during those investigations to the applicant's current police chief without fear of civil action. Currently, polygraph examiners are required to notify the Maine Criminal Justice Academy of any information that is criminal in nature, whether the individual has been charged or not, but still that information cannot be shared with the candidate's chief. It is my understanding that the Maine Criminal Justice Academy can only say that the individual had issues with the polygraph exam. What does that mean to the employing agency? Does the employing agency have to wait until something bad happens to learn the stuff if there is a problem lying in wait? The bottom line is that law enforcement executives are apprehensive of sharing truthful information about bad employees out of fear of being sued. Instead, some law enforcement executives acknowledge employment with wink and a nod in hopes of giving subliminal messages to the hiring chief, and there is an issue with that employee. This is inherently wrong. This bill will never affect an overwhelming majority of police officers in the state of Maine. As the saying goes, no one dislikes a dirty cop more than good cops. At a time when we are looking for ways to hold bad cops accountable and remove them from the profession while ensuring that only the best remain on the job, this bill is an important step in attaining that goal. We understand that police and corrections reform is a challenging issue and there are many stakeholders. We're looking forward to reviewing all of the testimony presented today and working with the committee and interested parties to find ways to improve our public safety and correction systems. Thank you all for your consideration, and I'm optimistic that we can arrive at a successful report, and maybe we'll be able to get together with some mealworms to eat in the future. So there's where I'm at.
Thank you, Representative Corey. Questions? Representative Pickett, please.
Yes, thank you, Madam Chair. And Pat, you notice I'm not wearing my red shirt, so you're okay.
I know he gets fiery when he's wearing his red shirts. You got to be a little bit worried about, how hard he may question you.
I wanna respond to the question that you asked in one of the paragraphs where you said, what does that mean to the employing agency? Does the employing agency have to wait until something bad happens? And the answer to that question is when they receive something in there to the effect of during the polygraph, they had issues.
Yeah.
What that says to if I were the prospective hiring officer, agency, and I got that information said to me and nothing else, then I would like to think that anybody in the hiring position at that point would turn around and they would take and inquire of the candidate what the bad issues were. You can't have it released by the polygraph examiner, but unless I'm wrong, I don't believe there's any reason why you cannot ask that question to the potential employee. They don't have to answer it, but you can ask it. So that is the answer to that question.
So I don't think that that's Chief Joyce's concern. I think Chief Joyce's biggest concern is that if he interviews somebody and then he finds out about potential criminal, activity or things that, aren't beholden, to being, a good police officer, that he would be able to, then go to the officer's, current police chief and say, hey, we have a problem here. I learned this information through the interview process, but he's worried that he can be held civilly responsible, for sharing, potentially very important information. I don't believe that he would hire somebody that would fail a polygraph exam. So, but he'll be here. You can ask him that question for sure.
And if I may, Madam Chair.
Please.
And a law enforcement agency that has a prospective candidate, before that candidate is ever hired, they are going to put them through a polygraph and a psychological evaluation. And a lot of information there by the person who is in the hiring is going to be brought to their attention. And that's going to really root out a lot of things before you ever get to that other question. But that's just stuff I just wanted to get out there so people would understand. It's not just go in and sit down and say, hey, I like to go to work for you. It's a pretty grueling, but it's something we welcome as law enforcement officers because we want people to know that we're above board and we have integrity. And I think all officers really want people out here to understand that. Thank you.
Yeah. And, I was thrilled when, Sheriff Joyce came with this piece of legislation and said, look, this is something we think we can do that would make a difference. So.
And I just want to let everyone know, as Representative Corey mentioned, Senator DeChambeau and I have spoken, and it'll be a little out of norm, but we are going to invite Sheriff Joyce to deliver testimony at the beginning of the work session. Representative Corey had requested for this to be rescheduled so that we could hear from Sheriff Joyce. The Speaker of the House approved that request, and unfortunately the Senate President denied the request. I don't understand why. We're disappointed in that. So that's why Representative Corey is here today. We usually do give courtesy to people that need to reschedule. That was not given. So Sheriff Joyce, I hope you'll all join me in welcoming him to testify the day we have the work session. He is doing the people's work by participating in accreditation, something we require in this committee, which sort of, for me, added insult to injury. So thank you, Representative Corey, for rising above and being here to present. And we'll make sure that Sheriff Joyce has the opportunity to present as well. Representative Pickett, do you have a
Just real
question?
quick.
Please.
Just real quick, I'm also going to say a good section of my testimony came directly from Sheriff Joyce. A lot of that was his words. Everything between, you know, the first paragraph and the last paragraph was Kevin's.
Thank you. Representative Pickett, a question?
Yes, I wonder if it would not be good where we had a yes and a no from the Speaker of the House and the Senate President, is just to follow everything that we should. If we, at some point, whether it's now or after this hearing is ready to be closed, if we take a vote of the committee on whether or not he should be allowed to testify where it is routinely out of order. I just wonder if we had an official vote on that, if it might not be better to have in the record.
I'm happy to do that. Thank you. Good idea. Any legislators here to testify on LD 573? Seeing none, I'm now taking testimony for those here to testify in support of LD 573. And if anybody is in the waiting room, please raise your hand if you'd like to testify, and Deb will move you over. All set, Deb, on proponents to testify?
Looks like it.
Thank you. I'll now take testimony from anyone here to testify in opposition to LD 573. Seeing no hands. Now taking testimony for those neither for nor against. Yes, Ms. Bissell.
And thank you, Representative Warren and members of the committee. As I just testified on the other bill, I just want to point out, you have my written testimony with more information, but I just want to point out first, it's not clear whether the employment records would include pre-employment information such as polygraphs, criminal background checks, and psychological exams. And under Title V, Section 7070, this information pertaining to state employees is confidential even to the applicant. So we would suggest that there be an addition of notwithstanding language to specifically allow the release of those records by the previous agency to the hiring agency. And in addition, we would suggest that the bill be clarified to ensure that the employee will not be provided access to this confidential information. And second, the bill provides that the law enforcement or correctional agency providing the records subject to the waiver is immune from liability, and that the hiring agency, but there's no similar immunity for the hiring agency when it uses the information to make hiring decisions. And then third, just pointing out and recognizing that the bill adds another step to the hiring process for the state's law enforcement and correctional agencies, requiring additional time for human resource staff, which would extend the time it takes to hire these essential law enforcement and correctional officers. And thank you again for the opportunity.
Thank you. Questions for Ms. Bissell? Seeing none, thank you. And we will be holding the work session on these two bills together, so.
Thank you.
Thank you. Anyone else here to testify neither for nor against LD 573? Seeing none, let's do our vote before I close the public hearing. Representative Pickett, would you like to make the motion? And you might start by saying, I'll make a motion, we'll suspend the rules at the work session.
Yes, Madam Chair, thank you. I move we suspend the rules and I make the following motion to vote to see whether or not the committee will allow the testimony of Sheriff Kevin Joyce, where he was unable to be here today to testify in committee at the public hearing, to give him his chance to talk with us at the beginning of the work session. Thank you.
I second that motion.
Moved by Representative Pickett, seconded by Representative Morales. And I think since this is a procedural, let's not do a roll call. Can we just, if you are in favor, please raise your hand. And I see that the vote is unanimous in favor of hearing from Sheriff Joyce at the work session, at the beginning of the work session. Thank you all very much. Thank you, Representative Corey. Yes, please, you have something to add?
No, I just want to thank you all and everything. If we were all in the same room and I was leaving the room, I would thank everybody as I left. So thank you. Y'all have a good day.
Thank you. See you soon. Okay.
Oh, and thank you. Just real quick, thank you, Charlotte, for fighting for us to get Kevin
Always.
Joyce in touch. So thank you. Bye-bye.
Welcome. Take care. Closing the public hearing on LD 573. And next up, our final bill of the day is LD 546. An act to implement the recommendations of the Maine Juvenile Justice System Assessment and Reinvestment Task Force. And I'm just going to look in participants to see if we have Representative Brennan here.
I did call EDU, so he should be here momentarily.
Wonderful. Thank you. And I notice we have a lot of attendees here today to testify. And just to let you all know, as soon as we hear from the sponsor, we will take you from same groups as usual and move you over. Deb, did he give you a sense of how quickly he'd be here?
I spoke to Sam, the clerk, and he said he'd let him know right away. So,
okay. This might be a good time to take a 1-minute refill your coffee break. I'm just going to take a minute.
hello, Representative Brennan. We're taking a 1-minute break while we were waiting for you. Everyone will be right back.
Good morning, Representative Brennan. Oops, you're on mute.
Well, I been sitting in education, we've had a presentation about CTE and the funding formula for CTE. And it's, it is definitely a maze to kind of work through it. So I'm going to have to readjust a little bit from CTE funding to criminal justice.
What does CTE stand for again?
Career and technical education.
Oh, yes, of course.
And it, in the last, 2 or 3 years, there's, under the LePage administration, there was a lot of interest in CTE. And so they're adjusting the funding formula. So now there's hold harmless in it and all kinds of other changes that have been made. But the enrollment, there are about 8,000 students across the state in CTE. And then there's issues about aligning the curriculum with their sending school, with the CTE school and those type of things. So I won't say that criminal justice is easy by comparison, but we don't deal with as many funding formulas.
Right.
So Charlotte, you're not teaching now, are you?
I took the semester away from teaching. Yeah.
And how's the enrollment been at UNE?
It's pretty good. There's not a lot of sections because, for the same reason, and it's all now online. So you know what I mean? That doesn't require as many sections of live, the 2 different sections.
Right. So they don't have any live students now, on-campus students?
They're doing Zoom.
Oh, they're all, so
Yeah.
So the ones that they're doing, they don't have, it's all remote?
Yes.
Wow.
Yep. I have an intern who's a UNE student. So, yep, she's spending a lot of time on Zoom, just like we are.
Well, I have to say I'm fascinated by the fact that we can have a whole legislative session virtually, but it's just not as good.
No.
And it's not the same.
Yeah. How much time we have to spend on the phone to try to get stuff done. Like you and I tried to connect with each other, and it's just, I end up playing so much phone tag with people when we could just be seeing each other in the hall. It's like, it's hard.
Just trying to do scheduling with and caucusing and trying to workshop bills. The coordination from that, it's all twice as long.
Mm-hmm.
Before you'd sit down with your committee clerk and boom, boom, boom. And now it's 3 Zoom meetings just to figure out a time to schedule.
Mm-hmm.
So it's much more time consuming. It's much more tiring, and it's not as satisfying.
Mm-hmm.
You mean this isn't how it's always done?
The thing that I know is that we aren't alone, right? I see that my constituents who are in the same, it's not like it's something worse for us, right? Our constituents are also having to work from home, and it's not fun for them either. Teachers who are having to do Zoom and, so I think we can understand where they're coming from as well because of our experience.
Yeah.
All right, looks like we're getting back together. So we are going to open the public hearing on LD 546, and we have Representative Brennan with us. Welcome.
Thank you, Representative Warren. And is Senator DeChambeau there or?
She's at the Government Oversight Committee today, so she'll join us. Yeah,
I thought for sure she'd come back just so we'd have a chance to see each other. But
she might be here before we're done.
But anyway, thank you very much, Representative Warren, members of the committee. And I do want to do a special recognition to Representative Rudnicki that for 2 years we were seatmates together on the Education Committee. And I guess the experience was so unpleasant for her that she decided to jump to the Criminal Justice Committee rather than go back to the Education Committee with me.
Well, we are very happy to have her. So
Well, I'm sure you are. And thank you very much. And I'm very pleased to have the opportunity to once again present LD 546, an act to implement the recommendations of the Maine Juvenile Justice System Assessment and Reinvestment Task Force. And I do not intend to read my testimony. I'm sure that everybody has a copy of it and you can read through it. What I'd like to do is just briefly go through the history of the task force. And also for members of the committee that are new, this bill is very similar to a bill that was submitted to the committee in July and passed by the Criminal Justice Committee in July. But like hundreds of other bills, it never made it to consideration by the House of the Senate or to the governor. So for those of you that have been on the committee before, you've probably seen portions of this bill with some amendments that I will go through. Very quickly, the Juvenile Justice Reinvestment Task Force was first convened in May of 2019, and it was jointly chaired by myself, Commissioner Liberty, and Jill Ward from the University of Maine Law School. We were fortunate enough to get a grant of $250,000 from the Juvenile Justice Advisory Group, which allowed us to hire a national consulting firm with an expertise in criminal justice, juvenile justice matters, to work with the task force. We had over 30 people that served on the task force from throughout the state of Maine, and we spent a year meeting with members of the public, stakeholders, public forums, public hearings, survey monkeys, all kinds of different avenues that we could think about to gain some type of understanding of the juvenile justice system in the state of Maine. In February of 2020, the task force and the consultants released our report. The first report had 161 pages, and I will spare you going through page by page the report. But I will promise you that if you go through the report, you will see a comprehensive analysis of the juvenile justice system within the state of Maine. And this report provides the basis, or is the basis, for the bill that I've drafted and presented to you today. So I do think we have a report that was fairly lengthy, fairly exhaustive in its nature, and it really provides quite an overview of the juvenile justice system in the state of Maine. So this bill, LD 549, the very first part of the bill, and it may seem a little bit like a non sequitur, but it's really not, but it repeals a section of current law that says, that allows for a youth to be held at Long Creek, even simply because there's not another placement in the community. So we had this discussion during the public hearing earlier, and there was agreement, not agreement, but there seemed to be a lot of people that agreed that we should repeal that provision, and that there should not be people committed, youth committed to Long Creek, simply because there's not another placement within the community. So that's what section 1 does of the bill, is repeal that section. Section 2 of the bill has to do with benchmarking. And in the original bill that we were looking at back in July, there was more extensive metrics that were applied to the benchmarking in terms of timeframes and things. As of last week, there were 26 youth either detained or committed at Long Creek. And so the language here really leaves it to the Criminal Justice Committee working with the Department of Corrections to establish those benchmarks going forward. Section 3 has language which basically transfers the operation and the oversight for the Juvenile Justice Task Force to the Juvenile Justice Advisory Group. So we'd like to continue that task force and have them work on overseeing and continuing to make sure that we implement the recommendations that are found in the task force report. But that task force, which really had been somewhat freestanding, would now operate under the auspices of the Juvenile Justice Advisory Group. The fourth part of the bill, section 4, has to do with annual reporting that would be provided by the Department of Corrections to the Criminal Justice Committee on a variety of different issues related to the juvenile justice system within the state of Maine. Section 5, I really think is a part of the bill that I hope the committee will spend just a little bit of time looking at. But it asks for the Department of Corrections over the next year. But this whole section could be accelerated depending on what the committee decides. But that section asks the Department of Corrections to identify 2 to 4 sites across the state of Maine, at least one in Cumberland County and one in Penobscot County, that would then host secure treatment residential programs for juveniles in the juvenile justice system. I think this section 5 is critical for us moving to a place where those final 15 to 25 youth at Long Creek, that we would be able to place them within the community. I do believe that planning process, again, could be accelerated, and we might be able to talk to the Department of Corrections on how we might do that. Section 6 and 7, and I also have an amendment, which I think that you've gotten a copy of. The original bill asked for $3.5 million. This bill asked for $2 million, and $1 million of that money would go to the Department of Corrections for them to continue to build a community-based system of contracted services with community-based agencies. The remaining $1 million would be split between the Department of Health and Human Services and the Department of Education. And it's very important, I think you all know, that going forward, building a partnership with DHHS, with DOE, is important because there's so much crossover between youth in the juvenile justice system, the Department of Education, and Health and Human Services. Also the contracting for the community-based services would be joint efforts between DOC and DHHS. There has been $100,000 more recently that DOC has transferred to the Department of Education for restorative justice purposes. I think that's a very positive development, and I think that if we can provide more resources and move more resources in that direction, that would be very helpful. There's also section 7 of the bill. This is part of the amendment that actually it talks about, it was in the original bill and somehow in the drafting, I dropped it along the way, but it calls for the department to complete a strategic plan for the juvenile justice system and submit that plan on I think it's a yearly basis to the Criminal Justice Committee. If you look at the addition, the amendment to the testimony, I think that was provided to you. And if you just scroll down, it gives a breakdown of the $2 million between the Department of Corrections, Department of Health and Human Services, and DOE. So that's a quick summary of the bill. I'd be more than happy to go back and review any parts of the bill that you would like to discuss more. I do believe that if this committee adopts this bill and we follow forward with this bill, with the Department of Corrections, with Human Services, with DOE, that within the next 18 to 20 months, that the number of youth at Long Creek should be significantly less, if not at zero. I believe that the $2 million allocation will allow us to develop appropriate placements in the community for a portion of those 26 that are still there. And I do think that once we develop the secure residential facilities, which would be dramatically different than Long Creek, they're not intended to be mini Long Creeks. They're intended to be residential programs that are secure but focus on treatment, that we could really be looking at Long Creek no longer being used for incarceration and detention purposes as we know it today. So I'm very optimistic about the bill. I'm optimistic about the process that we undertook in order to get stakeholder input and stakeholder agreement on the bill. And I think it's a prudent but clear pathway to dramatically change the way that we incarcerate and detain youth within the state of Maine. And I think finally, all of us, the obligation that we have was very clear in the report, is that we have youth today, too many youth today at Long Creek that are only there because we don't have a robust array of community alternatives. So again, I think this bill combined with other initiatives within the department will allow us to have those alternatives in the community. And I hope you will join me in supporting the bill and allow us to move forward. And at this point, I'd be more than happy to answer any questions.
Thank you, Representative Brennan. I see we have a question from Representative Pickett.
Thank you, Madam Chair. Thank you, Representative Brennan, for being here. My question would be, one of my questions would be, why do you feel the need to reestablish the Juvenile Justice Task Force to help implement the recommendations? Do you not trust the DOC to be able to take care of that themselves, to implement those recommendations? Because they had a seat at the table, as far as I know.
Right. No, that's not the reason why. We had the task force, we had a terrific working relationship with the commissioner, with other stakeholders that are involved in the juvenile justice system. I just believe that given the array of people and the voices that were represented on the task force, that having those voices available and continuing to look at these recommendations and how we implement those going forward will be very helpful to DOC, to the legislature, and to making sure that we're continuing to move in the direction that's recommended by the task force report. So I look at it as a partnership, and I look at it as a continuation of a very positive relationship that we've had over the last 2 years.
Okay, thank you. Could I ask another question, Madam Chair?
Yes, you may. Yes.
The other thing I would ask Representative Brennan, I think it's a great goal to have. I think we all share in it, to have someday get to the point where we never have to incarcerate a juvenile. But I think it really is something that's never going to happen. I think because of society. I mean, there's going to be times when we're going to have people detained and incarcerated, juveniles as well as adults, and we know that. So I think we all want to at some point get away from being in the big building that we have. But on the other hand, I don't want to lose sight of the fact that we can't be so geared toward getting every juvenile out from under Long Creek that we don't continue to realize that there are some juveniles, because of the crimes committed, that they are going to need to stay in detention, and sometimes for long periods of time. I know we don't like to think about that, but so my question is, the task force, I'm sure, knows that, and what is their thoughts on that? If you can, I know you were part of that task force. What's the overall thoughts on that?
Yeah. Well, thank you, Representative Pickett, and I respect that question, that perspective. And I don't believe, I've asked, I don't believe there's any state in the country that doesn't have some secure capacity for juveniles. And that's why I called your attention to Section 5, because I think that's a critical element to what we need to discuss and what we need to put into place as a state if we want to move away from Long Creek as being the primary source of incarceration and detention. And what other states have done is move away from, quote, a prison model or a building that's established as a prison that reflects more of a residential, smaller 5 to 6 unit with a focus on treatment, but still has a secure capacity as well. Could be staff secure and have other measures for security. But that's why that's in the bill for the next year or for some period of time. As I mentioned, it could be accelerated, that we have that discussion of moving away from the structure that we have at Long Creek, but that we develop alternatives within the community that are dramatically different than Long Creek, but still have some of the security and detention elements that you're talking about.
Thank you, sir.
Representative Morales.
Thank you, Madam Chair, and hello, Representative Brennan.
Good to see you.
Good to see you as well. I have two questions.
Yep.
The first one is about Section 6 and about the additional community funding.
Yep.
And I'm sorry I haven't had a chance to talk to you about this bill in this section, but did you consider that the funding that you're looking to put into the community would go through the Children's Cabinet and JJAG, which are already existing entities, so that you have the justice approach, minded, and as well the therapeutic sort of focus on children and ACEs, and as you're saying, what most of these young people need. Has that been a consideration for how that funding gets decided and delivered?
Yep. I guess the short answer to your question is no. I didn't consider that largely because unless things have changed, my experience with the Children's Cabinet is they just don't have the infrastructure or capacity or staffing to manage contracts or to do that type of provide the type of accountability that we look for when we're expending state money. And I think that would also be true of the JJAGs, that they have very limited staffing and they're just not organized in a way to be able to do RFPs, to oversee budgets and provide the administrative oversight that needs to happen when you're contracting millions of dollars. So if the committee or there's some way of talking about how they could have input or be involved in the process, I think that would work. But in my experience, the legislature usually demands some type of accountability when it's expending its money. And that's why typically when we contract, we do through the Department of Health and Human Services, Department of Education, Department of Corrections. So that was pretty much why I still look to the Department of Corrections. But I think one of the things that was a little bit novel, I won't say it was a radical change, but a little bit novel in the sense that what we tried to do is say that these contracts would be jointly reviewed by both DOC and DHHS, because again, we want to foster that relationship between the two departments because there's so much crossover between youth that are in the juvenile justice system and those that are in the DHHS system. And then obviously, I think you know this as well as anybody else, that unfortunately, oftentimes youth end up in the juvenile justice system because they've had significant disruptions and problems in the education and their education settings. So the more that we can keep youth in school and tracking educationally, the chances of them ending up in the juvenile justice system are dramatically reduced. So in the past, it's been difficult sometimes to have DOE as a partner at the table when we talk about juvenile justice issues. So the intent in the bill with this joint funding is to try to get the three major players together and be thinking about how they can assist youth that span different departments and different programs.
Great, thank you. And I do appreciate that comment about, you know, Children's Cabinet maybe not being able to administer contracts, but that's why we have DAFs, right? And JJAG certainly could administer some contracts, but I appreciate that answer. The next question that I have is around workforce. And what discussions have you had around the number relative to the 26 children that we have there today, which is down, I think, by 3 from last month. We had 29 in there. And so what your bill really raises that issue of a structural change. What have the discussions look like around workforce?
You mean workforce at Long Creek? Or
Right, related to your bill, right? I think how many, there are 175 staff members, corrections officers at Long Creek. So how does that tie into your bill?
Right. Well, one thing, just to step back for a second, you know, a year and a half ago, and again, Colin and Neil will be able to answer it more, but there were probably 50 youth at Long Creek, somewhere between 45, 50, 50, and now it fluctuates between 25 and 30. But I think you also know the department has presented a proposal to you that looks at ways to take almost $6 million of the budget currently at Long Creek and staffing and transfer that to community initiatives, primarily aimed at making sure that young women are no longer at Long Creek and are in community placement, as well as a number of young men. So what I would anticipate, Representative Morales, and I can't give you 100% assurance because I'm not the Commissioner of Corrections, but as we move forward again in Section 5 with looking at these residential programs in the community, I would suspect that there would continue to be a transfer of funds from Long Creek to support these residential programs across the state. So I think at some point the workforce will end up following wherever we're able to designate and develop those residential programs, and that the workforce will proportionately continue to decline relative to the number of young people who are there. And I think it's a very positive step that the commissioner has put a proposal before you that basically transfers almost $6 million of money for community purposes or community programming. Does that?
Thank you.
Answer
I'll stop there. I think others have questions. Thank you so much.
Yep. All right.
Representative Lookner.
Thank you, Madam Chair, and thank you, Representative Brennan, for your work over the years on this extremely important issue. So I'm looking at the Juvenile Justice Assessment report, and it recommends that we create an accountability mechanism to oversee these needed reforms. So when I was listening to, I guess it's Section 5 in this bill about DOE and DOC working together to determine how these contracts are meted out, does that kind of get at this needed accountability mechanism, or is there something else in here that would sort of create more oversight that's independent of any of our departments as they currently exist?
Well, I think, again, the short answer, Representative Lookner, is yes. But at the same time, what we've tried to do with the bill and tried to do in the discussion is to keep all the task force members at the table, and they represent virtually every interest group in the state of Maine that has anything to do with juvenile justice. We keep the Juvenile Justice Advisory Group at the table, and then we're asking the Department of Correction to partner with DHHS and DOE in the distribution of money. So I would hesitate, or I guess I'd push back if somebody were to say that this money that's going to DOE, that it's going to be totally up to them to decide how the money is being spent without input from a number of different voices and number of different stakeholders across the state of Maine. And that was intentional, as I mentioned before, to bring in more departments and to continue to have the task force going forward, because it is so representative of the many voices involved in juvenile justice. So I would hope that we would continue to have those type of discussions as this money is used for contracting within the community in terms of what's the highest need, what are the best programs, and how can we have the most accountability. So if there's another mousetrap that people have, we could certainly talk about that, but I think it'd be somewhat rare that you would find legislation that involves so many different departments and potentially so many different voices in the decision-making process.
Okay, thank you.
Representative Rudnicki.
Thank you, Madam Chair. Good morning, Representative Brennan. Representative Brennan was my seatmate in education for 2 years. So I just a quick question. Have you seen the commissioner's plan moving forward for the juvenile justice?
I have.
In Long Creek?
Yes.
And how does that compare or work with what you're presenting here?
Well, Representative Rudnicki, you weren't here when I mentioned the fact that we were seatmates and that somehow it was such a difficult process for you, you decided to go to criminal justice rather than stay in education. But we do miss you on education. But to answer your question directly, I have met with the commissioner. I've met with Colin O'Neill. I have reviewed the plan, and I think that they go hand in hand. What this bill would do, if we follow this bill, it would again significantly reduce the number of youth at Long Creek. It would continue to accelerate the transfer of funds and resources at Long Creek to the community, which the commissioner's plan does. It has $6 million that it reprograms outside of Long Creek. And I think that they work hand in hand, and they will be working parallel together. And I think, again, Section 5 in this planning process will further reduce resources at Long Creek, and that we will see a considerable shift of resources from Long Creek to the community setting. So these do not in any way, they're cross purposes. They, I think, are parallel processes that complement each other.
Thank you.
Representative Rudnicki, I told Representative Brennan when he mentioned that you were his seatmate that his loss was our gain. So other questions for Representative Brennan? Representative, I have a couple of questions for you. I'm just interested. So we are now 2 years past, when we started this process last session because of the pandemic, et cetera. And we have, I think you mentioned 26 youth.
Yep. As of last week.
26 youth calling the facility home. What is your hesitation in putting in your bill, and maybe I'm remembering this wrong. I thought that in the other bill, there was some finality, some time when we would actually close a facility that costs Mainers $18 million a year and originally had over 200 youth in it.
Yep. Representative Warren, I would never use the word wrong when I'm responding to you or in regards to you. But the very original bill, going way back to 2019, in December of 2019, there was a bill that I submitted to establish a planning process that did have an end date to it. And I think it was 2021 that we established a planning process in 2019 that would look to eventually close Long Creek by 2021. That bill was we never moved that forward because we created the task force outside of a legislative study. And so the bill that came back to you in July, that was considered by the committee in July, really embodied the recommendations of the task force and set up the process that we're talking about here. So your recollection about having a date certain was accurate, but that bill never moved forward, and it did not surface again in the task force report bill that you saw in July. The second thing that I guess I'd say, and this is, I would have said this a year ago if we'd been, March a year ago, we didn't anticipate obviously the pandemic, and that did set this time frame into motion in a different way. I think that if last March we had heard this bill, which we had planned to do in March of 2020, we would have accelerated some of this planning process and some of the discussion, and we'd be in a better position to be talking about what the future of Long Creek looks like. So I have been humbled, as I'm sure you have, by the pandemic in terms of being able to make predictions about what the future might look like. But given the fact that this bill is before us, and if we can move this forward and we meet the obligations that are in the bill in terms of planning and reports, I do feel confident that those 26 youth that we currently have at Long Creek, that in 18 to 20 months will no longer be there. And that they will not be replaced by another 26 youth.
Thank you, Representative. So can I take that as, if this committee, as we work this bill and we have another bill coming at us, creates a timeline whereby we move away from a piece of real estate that no longer serves us, and can create a timeline to get that off the backs of the main taxpayers, can I take your comments that you would support that?
Not necessarily. I'm very reluctant, again, because of the pandemic and other things and a lot of other external factors that come into play, to put a hard deadline on it. I do think, again, the process that's outlined in the bill takes us there. But, again, in all honesty, Representative Warren, last March, I felt that we could get to a certain place with certain benchmarks, and that was disrupted for a year due to the pandemic. So at this point, I feel comfortable by saying that if we engage in this type of planning, if we engage in this type of discussion, that I think we do get there. But I think putting a time certain on it could end up being problematic from both a political perspective as well as a program.
Thank you for that. I just have a final question, and because you used the term mini Long Creeks. You said, we don't want to create mini Long Creek.
Right.
And I wrote that down. And would you agree that what makes something no longer a Long Creek is that it's no longer funded by the DOC, right? What you said was, we want secure, and that's the thing that often gets, I think, sometimes confused. People think that we're just saying, none of these youth need to be in secure confinement anymore. And sometimes I think it's because that's easier, right? To go to either the black or the white. We forget there's a lot of gray. We forget that secure confinement can happen in smaller places without costing $18 million a year. So if we don't want to create mini Long Creeks, that are still secure and they're supportive residential environments, isn't that called residential facilities? Isn't that funded by HHS? Isn't the fact that it's funded by DOC, doesn't that make it a mini Long Creek?
Well, let me make a distinction for you, and maybe clarify this at the same time. I mean, on the task force, and you were on the task force, and you heard from people across the country, in particular New York, and how they have reduced their population in larger facilities by moving to smaller residential facilities. And it's not an exact science, but we were talking about facilities that would be 5 to 6 units, 5 to 6 people would be able to stay there at any given time. Obviously, that's substantially different than at Long Creek, where during the time when I worked there were 240 youth at Long Creek. So I think if we start looking at smaller, quote, residential, when you get down to 5 and 6 units, that's fairly small, and that's really not very institutional, given what we've seen in the past at Goodwill Hinckley and other residential programs that have been larger institutions. But the difference between the youth that are potentially in these residential units is that they're in the juvenile justice system and they have been adjudicated. That's different than a youth that might need a residential placement due to mental health issues, behavioral issues, or other health-related issues. And where this, I don't want to make this more complicated, but I think you do understand this. We now have, last I heard, 40 to 50 youth in out-of-state placements. And they're not there because they've in the juvenile justice system. It's because we do not have appropriate placements within the state of Maine for residential placements. Representative McCray has a bill in because unfortunately we have too many young people that get stacked up in emergency rooms and they have mental health needs and there's not appropriate placements within the community. So part of this discussion is looking at what type of residential placements we have in the community that can deal with a number of different youth, some that have been adjudicated through the juvenile justice system, some that simply have behavioral issues due to mental health and other issues in their life. And at the same time, we don't want to go back to a model of Goodwill Hinckley. I don't want to pick on Goodwill Hinckley, but on large residential programs that we had in the 70s, 80s, and 90s that were not very effective and very costly. So to answer your question, I think the distinguishing factor is that for the youth that we're looking for in these particular programs, their involvement in the juvenile justice system and the court system, and there's been some decision regarding them having been adjudicated. That's noticeably different than a youth that would need a similar type facility that has not been involved with the juvenile justice system. So I think that's a very long-winded answer, but it reflects the distinction that I have about this in my head.
Thank you. It's helpful. Representative Morales.
Thank you, Madam Chair. Representative Brennan, I wanted to go back. I pulled up the plan that we were provided by the Department of Corrections that you referenced and indicated that your bill is in line with this plan. You referenced a $6 million that's going into the community. And when I look on page 4 of the plan, I don't see $6 million going to the community. What I see is about 1.4 going into the community. And so the others is the department creating a boys and a girls home that would be staffed by corrections officers. So not getting at the therapeutic aspect of it, which you and I both sat on the committee, on the task
Yep.
force, and, you know, clearly the children who are there are suffering from ACEs, they're suffering from trauma, they're all indigent because they all qualify for Maine Civil Indigent Legal Services. And so, you know, you did say in the beginning, I think in your testimony today, that that any residential transference from Long Creek would include therapeutic,
Yep.
because that, I think,
Yep.
because you agree that that's what they need, right?
Absolutely, yes.
So what is this, if you can sort of break down that 6 million and
Yeah.
how that is
Well,
laid out?
I appreciate that question, Representative Morales. I will do the best I can to answer it, but the commissioner and Colin O'Neill, who I think are both here, probably do a better job than I can. But you're absolutely right. There's about $1.5 million of that 6 million that does go into community programming. And in fact, and I can't say that I was gifted enough or clever enough to come up with all of this, but if you recall last year when the bill came forward in July, we were asking for 3.5 million. And so there's 2 million in this bill, and then they have 1.5 million, which adds up to the 3.5 million that we originally had asked for. And again, that wasn't because we all sat down and figured out how the numbers would work out that way. It just so happened that they do. You're also right that the majority of the money, that 6 million, and I believe last time I looked at it, it was close to that number, goes to provide programming outside of Long Creek for young women and for a program for young men. And so maybe I need to be a little bit more precise in terms of talking about this in terms of community programming, or you and I can come to a better agreement on the definition. But I think the point that I was trying to make is that they are taking staffing and they're taking resources that are now in Long Creek in the facility, and they are now moving to the community. But certainly you're right that they continue to be DHHS staff, and they're not community programming in the way that we would look at Opportunity Alliance or Tree Street or those type of programs.
You mean they'll be DOC staff, not DHHS staff, right?
Right, that's correct.
Right.
That's
Yeah.
correct. But going forward, and you're absolutely right, and I would be held accountable to this, that the residential programming that we're talking about in this planning process here, I do think it would be very focused on rehabilitation, on therapy, and it wouldn't necessarily include, corrections staff in order to staff those facilities. And we've had in the past in the state, we have had staff secure programming. And as Representative Warren pointed out, that was not necessarily provided by the Department of Corrections.
Thank you.
Yep.
Any other questions for Representative Brennan? Seeing none. Thank you, Representative Brennan.
Well, I totally appreciate the opportunity to present the bill. I look forward to being able to continue the discussion in a work session. And thank you very much for the questions and for the detailed attention to this. And it's warranted, and we need to do this. And I'm excited about what the possibilities are. And I really believe that we're moving in the right direction, and that we will all, within a fairly short amount of time, look back and say, this was a milestone in terms of transforming the juvenile justice system in the state of Maine. So thank you very much. And I look forward to seeing you again shortly.
Thank you, Representative. Now we'll take testimony from those testifying in support of LD 546. And if you would like to testify in support, please raise your hand now. Deb will move you over to join us, and we'll start receiving that testimony. So all those who are here to testify in support, please raise your hand. And Deb will move you over. Welcome. Good morning, Commissioner Liberty.
Morning.
Take it away.
All right. Good morning, Representative Warren and distinguished members of the Criminal Justice and Public Safety Committee. I'm Randall Liberty. I'm the Commissioner of Corrections. I'm here to provide testimony in support of LD 546. As the committee is aware, MDOC has been an active partner in the work to improve services for juveniles involved in the Maine juvenile justice system. We see this bill as an extension of the multifaceted collaborative work that has been taking place over the last 2 years to improve outcomes for justice-involved youth. As the committee knows, the MDOC is currently fulfilling or working towards the fulfillment of most of what has been outlined in this bill. We're committed to being in an organization that is part of the solution, as is evidenced by our support of Representative Brennan's bill. The legislature, our participation in the Maine Juvenile Justice Systems Assessment Reinvestment Task Force, and our close partnership with DHHS, the Children's Cabinet, and our collaboration with Mark Solar and the team from the Children's Center for Law and Policy. Most recently, the MDOC presented to this committee, to the Juvenile Justice Advisory Group, members of the Reinvestment Task Force, and other stakeholders, the MDOC's Division of Juvenile Services, a new action plan. This plan details the actions of the department and will implement to reduce secure confinement, to expand community-based programs, initiatives, and to build meaningful cross-systems collaboration, and to implement the recommendations of the Maine Juvenile Justice System Assessment and Reinvestment Task Force. We're here today standing with the sponsor, with the advocates, and with those interested in focusing on the attention on reducing the use of secure confinement by increasing the use of community support. As the committee reviews the language in this bill, we ask for consideration of an amendment to streamline the reporting requirements outlined in this bill. Look at sections 2, 4, and 5. They require MDOC to report out a variety of overlapping topics in slightly different ways. Respectfully, the MDOC proposes combining these into one section that requires the MDOC to, every 6 months, prepare and submit to this committee a comprehensive report on the juvenile justice services. This report, as you'll see outlined in the proposed language, would include all the information requested in this bill. Regarding section 1, the department is in support of repealing the noted subparagraph. Regarding section 3, the department understands that there's amended language forthcoming, so we'll wait and see what exactly that language looks like. Regarding section 6, the department is comfortable with the spirit, as we currently have contracts with 26 providers in the community, which total $3.3 million investment. However, we believe the language in this section should be streamlined and include a sunset provision. Regarding section 8, the department does not fully support the funding allocation, as we believe we're able to use existing resources as we reduce secure confinement, expand community-based programs and initiatives, build meaningful cross-systems collaborations to implement the recommendations of the task force, as outlined in the new Division of Juvenile Services Action Plan, as we've presented to you in the past. This concludes my testimony, and I'm pleased to answer any questions you may have.
Thank you, Commissioner. Questions for Commissioner Liberty? Representative Morales and then Representative Pickett.
Thank you, Commissioner. My question is, it's largely around, because I appreciate the movement. I really appreciate where we're going. I appreciate that you're listening to the task force and making changes. And as I really think about how do we provide the best care for the children in our system, you know, I think about what system is the appropriate system to provide the care they need of that untreated trauma, right? That maladaptive behavior, those behavioral health challenges. And as we work towards our plan and our goal and our cross-systems collaborations, what are you thinking about that in terms of down the road, what this looks like? Does it have to stay under the Department of Corrections? Or are we talking about, and I'm asking you in your conversations, are you talking about how can we kind of shift our focus?
Well, as you've seen in our action plan, we are shifting our focus to make the majority or a large portion of as we evolve for those youth to be in the community and community-based residential treatment and assistance. And we will be collaborating with Health and Human Services to do that, with the Department of Education, and sort of normalizing the life of these youth that have been traumatized and come to us with mental health, substance use disorder, a bunch of many different challenges. But I see this evolving into be majority community-based. And I think that they can receive the treatment and programming they need in the community as best we can.
Thank you.
Representative Pickett.
Yes, thank you, Madam Chair. Thank you for being here, Commissioner. I guess the first question I have several. First question I have is, do you see a continued need to have the task force operational, or do you think you're capable of initiating their recommendations on your own and having those contacts you made through that task force available to you so that you can reach out to them if you have any kind of concern? Or do you feel you need to have that task force still being reinitiated and then have them as a partner in doing this?
Thank you, Representative. That's a good question. I'm confident and I'm committed to this evolution of the way that we work with youth in our system and in the state of Maine. I did find value in the task force. It provided me an opportunity to hear voices and voices that I may not normally hear. I enjoyed the fellowship and the good spiritedness of this task force. I felt that much good came of it. I particularly enjoyed working with my co-chairs, Jill Ward and Representative Brennan, working with Mark Solar and Colin O'Neill in the efforts that we performed. I do think there's value in continuing the work of the task force and continuing to hear all the stakeholders that are involved in the system.
Ask another question, Madam Chair?
Yes, you may.
Commissioner, in regards to the 2 other small, secure therapeutic residents for youth for the purpose of providing detention and confinement with a maximum of 20 youth, where, if any, have you given thought to placing those 2? We know there's going to be one in Cumberland and there's one in Penobscot. What's your idea on where these other 2 might be, or have you come to any type of conclusion on that?
Thank you, Representative. One is currently located in South Portland, as you're aware, and that's the STEPS program for our girls. We're currently working with a business now in the Androscoggin area. We're close to securing a lease there, so we'll have one in Androscoggin County. I would say within the next month. We'll begin that process. And then I think it's important that as we implement these residences and the youth are placed there, we begin our work. I think it's important that we pause for a bit, we collect data, see how it's working, see where the demographics take us specifically. Does that mean that we need something in central Maine? Not quite sure yet. Do we need something southern Penobscot County? Not quite sure yet. But I think it's important to collect the data and have data-driven decision-making as we decide where the placement of these residents should be.
Okay, so you would agree that then, or I'm not going to put words in your mouth. Would you agree that the taking a look at, even though it's not as populated as down in southern Maine, but taking a look at Aroostook County down east, that area there, taking a look at northern Oxford County and even though trying to make it so that these parents and other people involved in this that might be given visitation, those kind of things like that, would have opportunities to and not have to travel great distances at a time. So you're considering those things when you're considering where you might locate these. Is that correct?
Yes, sir, that's right. We'll look at the data to see where the youth are coming from. We know that they're best served in their communities. So it's important to be demographically diverse. It's important also to know that as we talk about the costs of these smaller facilities, I do not believe there'll be significant cost savings because the economies of scale of dividing them up and them being diverse throughout the communities, especially as we look at secure facilities and the modifications of the buildings that may have to be constructed as a result of that, will be revealed, I guess, as we continue to explore possibilities in those different areas.
And lastly, if I may, Madam Chair,
Yes, you may.
when we talk about the situation with the juvenile residents being in secured places, because we talk about a community services type secured premises, as well as Long Creek or a place like that, a detention facility like that. If the word secured is in that sentence describing whatever type of facility it is, are you comfortable with having juveniles in those type of places without having some kind of correctional staff or something like that, where it's a detention facility, or are you okay with having it staffed by civilians?
I think it's important that we have correctional staff that are there that are specifically trained to work with youth. And we're working with the Maine Criminal Justice Academy now, as the co-chairs are aware, to change the curriculum so that they're not receiving adult-like one-size-fits-all curriculum as they train, and they're receiving training that is specific to the trauma that youth specifically are exposed to.
And Madam Chair, I apologize, but I do have one more question.
Go for it.
The question would be, Commissioner, in your plan that you have right now, and any talks that you've had with the administration or anything of that nature, is there any type of one-time money that you have earmarked to go into this plan?
Thank you, Representative. I currently have no one-time money set aside. It is my intention and the intention of the executive to use existing resources for this transition.
Thank you, sir.
Representative Lookner.
Thank you, Madam Chair. Thank you, Commissioner Liberty. I know you put a lot of thought and effort into this plan, and I appreciate that work and thought you've given it. I've got two questions. So I guess the first really has to do with training. You mentioned that any DOC staff that would be in these facilities would have to have a certain amount of training working with youth and trauma informed and everything. And in my experience, going to USM and getting pursuing a master's degree, that's pretty extensive training that's needed. So what level of training would these staff be given? And, I guess like how long and sort of classes would they be required to take?
Sure. So the curriculum we're developing now will be a 6 to 9 week program for those individuals. It's important to remember also that the staff that we hire often have some level of education related to these fields. And so that's maybe in addition to that. But given the current workforce and the challenges, it can be a difficult environment to attract individuals into corrections where there may be other opportunities. But the curriculum we're developing now is consistent with the timeframes that are allotted by the Maine Criminal Justice Academy. 6 weeks for the basic course, and then probably 3 to 4 to 5 weeks as we develop this for specific additional training for the youth.
Okay, thanks. And my second question has to do with one of the recommendations of the task force. So they were recommending that we get rid of the 1-year mandatory minimum sentence for any juvenile committed to Long Creek. Is there anything in the DOC's plan that would get rid of that requirement, or anything in this bill to get rid of that 1-year mandatory minimum?
Thank you for that question. Nothing in this bill that addresses the 1-year minimum mandatory.
Okay, thanks.
Thank you.
Representative Pickett. Oh, maybe just your hand left up. Anyone else to ask questions for Commissioner Liberty? Seeing none. Thank you, Commissioner, for being here this morning.
Thank you, Madam Chair.
Good afternoon. Anyone else here to testify in support of LD 546? Please raise your hand. Seeing none, we'll now take testimony for those in opposition to LD 546. Please raise your hand and Deb will move you over. Thank you. So I'm seeing folks come in on the screen. Let's start with Mr. Joseph Jackson. Welcome. Good morning.
Good morning, Representative Warren, and greetings to you and Senator DeChambeau and the honorary members of the Criminal Justice Committee. My name is Joseph Jackson. I'm the executive director of Maine Prisoner Advocacy Coalition, and I'm here testifying as ought not to pass on Bill 546. I'm also a member of the task force, and as a member of that task force, I want to commend the chairs, but I commend Mark Solar and his team for a very thorough job. Really was impressed by their work. The reason I'm coming out as ought not to pass is because I believe that there were many recommendations that came from that task force, one of them which didn't shine a great light on the work of Long Creek, and feels like Long Creek should close, and that I really wanted to see a bill that was similar to the bill that Representative Brennan put in last year that called for an end date for that facility. I think the second thing I would add is that it didn't count, this bill does not count for the 8-digit figure that's associated with that. When we're talking about 26 youth that are currently inside, it's not just those youth we're talking about, and wondering what the jurisdiction is. This is a question that hasn't been answered as well. And so the bill fails to address jurisdiction. And as a member of the Juvenile Task Force, I heard clearly that in many states, the jurisdiction belongs to another administrative body that is tasked with the health and well-being of youth. I heard clearly that many youth find themselves incarcerated because they don't have a place to live, or that mental health services in our state has failed them. And that this bill failed to outline the community involvement in the continuum of care, because we know that we're talking about more than just these 26 or this small number of youth that are currently being held, but by a lot of youth that have fallen, that are being diverted, but don't know what kind of resources they're going to get to help them heal and grow. And then lastly, let's just face it, youth justice reform is racial justice reform. The demographics of those who are impacted by youth justice in our state is skewed heavily toward BIPOC identities and other minority groups. And so I would love to see some mechanism or strategies within any policy of bill that we create that's going to try to alleviate or reduce a disproportionate burden on minority groups, particularly youth of color. So I stand in opposition. Definitely respect Representative Brennan's belief that this will lead to the end of youth incarceration in Long Creek, but fail to see how we're going to provide those resources and supports for those folks who as we begin to transition into other settings. So let's conclude my testimony, and I will open for questions if anyone has any.
Thank you, Mr. Jackson. Questions for Mr. Jackson? Mr. Jackson. I just have one for you. I see you as a real leader in Maine around these issues. You lead the Maine Prisoner Advocacy Coalition. You work with Maine Inside Out. You work with Maine Youth Justice. You do lots of other things. Were you consulted when the DOC was working on their strategic plan?
No, I was not consulted, but I felt like, with the task force, that we knew that there was a plan of action that was to take place, and didn't feel like that those was fully implemented. And so, no, I was not directly consulted.
Thank you, Mr. Jackson. Representative Pickett and then Representative Morales.
Yes, thank you, Madam Chair. Thank you for being here, Mr. Jackson. Something you said at the end, it posed a question for me. You said, let's face it, youth justice reform is racial justice reform.
Yes, sir.
So where does the Caucasian youth come into play in youth justice reform, seeing you was on the task force?
Well, yeah, we did have youth that are of all demographics are being system impacted by the youth justice system. I think that when we look at the numbers of those young folks that are impacted and their representations in the population, that the numbers who are impacted looks a lot higher for those who are inside, who are impacted versus their representation in the population. And so when I talk about being racial justice as part of youth justice reform, I'm talking about what is the mechanism and the structures in place that are seem to be trapping and touching youth of color disproportionately.
So if I may, Madam Chair.
Yes, you may.
So Mr. Jackson, then if I'm hearing you correct, then I understand your feelings on that, but would you agree that in this whole program we're putting forth here, or trying to put program forth here, needs to be considered a youth justice reform in order for it to really identify? I know there may be certain groups in there, but in order, we're trying to help youth as a whole with all the different youth that are in there in its entirety, correct?
No, I agree wholeheartedly. I just think that when we look at the whole number of youth and that you're talking about, I think we would be, not living up to our responsibility if we didn't fail to look at the disproportionate number of particular groups that are finding themselves. So out of that whole of youth that are touched by the system, people do break down into other demographics, and so it's those demographics, as we heard, one being that almost all of them are indigent. I mean, that's a fact, and so it's not just about any particular race or group. It's about there are certain demographic and criteria upon which groups with young people fall into.
Thank you, sir.
Representative Morales.
Thank you, Madam Chair, and thank you, Mr. Jackson. I was wondering if you can, and I agree with that discussion that you were just having. And there was one statistic before I asked my question. It's very quick, that I learned that 88% of the young people incarcerated in Maine are disabled, and I learned that a few years ago as well. But my question is, what, in your experience, and I did serve with you on the task force, and I have great respect for your vision. What does a community-based residential small model, what should that look like? What does it look like based on the research that you've done and the community engagement you've done?
Well, I mean, it sounds like that we're not just talking about the Department of Corrections, we're talking about other entities that are in place. I mean, so let's just face it, a lot of young people suffer from mental health issues or other issues. And I fail to see how these issues are being served under the MDOC. And secondly, and this is why I said the resources to provide healing. As we talked about ACEs and other things, what is the other mechanism that is going to engage the therapeutic community? And so that I feel like that has failed to be fleshed out into this bill. And I think that was one of the things that we saw was part of the reductions was that youth were going to have access to these other services that were going to support them from being in contact with the criminal justice system. And one of the things Representative Brennan said to me, and I really applaud him for it, is that we now see there's 26, but he told me he worked there at one point and it was 240 youth. So let's not face it, the youth are still having problems. We're diverting them, but what are the resources we're doing to provide them from having this, contact with the criminal justice system? And whose responsibility is it?
Thank you.
Any other questions for Mr. Jackson? Seeing none, thank you for providing testimony today, Mr. Jackson. Just so folks have an idea, I have on my list Mr. Cabetta, Al Cleveland, Sky Goslin, and Tina Neto here to testify. Michael, you're next. Welcome.
Thank you, Representative Warren. And I want to take a guess that Senator Searle is the ranking senator. So good morning to you, Senator, and distinguished members of the committee. My name is Michael Cabetta, and I am Policy Counsel for the ACLU of Maine. On behalf of the ACLU and GLBTQ legal advocates and defenders, GLAD, who couldn't be here this morning, I'm here to oppose this legislation. I want to start by acknowledging the hard work that went into this bill. The bill sponsor and several members of this committee sat on the task force. The ACLU and GLAD were also part of the process. We are supportive of the general direction in which Representative Brennan wishes to move our state and the resources this bill dedicates to young people. But we share the concerns of the young people you'll hear testify today. For at least 4 reasons, we urge the committee to vote ought not to pass. First, the bill just doesn't go far enough. The CCLP report's ultimate goal, listed after 46 short, medium, and long-term goals or solutions, is to, quote, achieve removal of all youth from Long Creek. This goal is no different from the demand that formerly incarcerated youth have made. The bill before you does not strongly enough incentivize the closure of Long Creek. But since we all want our youth to flourish and not merely to survive, we must imagine a Maine free of youth incarceration. Second, not only does this bill not close Long Creek, but it urges the Department of Corrections to open up 2 to 4 new facilities in addition to Long Creek. This in spite of the fact that there are only fewer than 30 children currently incarcerated at Long Creek. While there are genuine disagreements as to whether new secure facilities would be needed if Long Creek is closed, we cannot support the building of new places to incarcerate children while also keeping Long Creek open. That would take us in the wrong direction. Third, there is no mechanism written into the bill to hold DOC accountable if it doesn't meet the bill's enumerated goals. The bill imposes reporting requirements on DOC, but neglects to include consequences or enforcement mechanisms for failure to abide by that requirement. Fourth, and perhaps most troubling, the bill proposes appropriations of $1.5 million to the Department of Corrections. While we are fully supportive of spending this amount of money on community services for children, we disagree that the Department of Corrections is the correct agency to receive these funds. The DOC itself testified that it does not want this extra money, that it has enough to spend on community-based alternatives from divesting from Long Creek. Our state spends $18 million a year to keep the system going. In order to adequately fund community solutions to youth needs, we ask the committee to close Long Creek and repurpose the funds used there for services that are healing rather than traumatizing. This legislation does not go far enough, and because it calls for further investment in the correction system, we ask that you vote ought not to pass. We thank Representative Brennan for his efforts, but we urge the committee to vote against this bill. Thank you, and I'm happy to try to answer questions.
Thank you. Any questions? Seeing none, thank you. Up next, we have Al Cleveland. Welcome, Al.
Hi, everyone. Thank you for this hearing. Representative Warren, members of the Joint Standing Committee, Criminal Justice and Public Safety. My name is Al Cleveland, and I am the campaign manager for Maine Youth Justice. We are a nonpartisan youth campaign fighting to end youth incarceration in Maine. We're calling for the closure of Long Creek Youth Development Center, the decriminalization of young people, and the reinvestment of the $18.6 million currently being spent to lock up Maine's youth. Maine Youth Justice is a campaign made up of young Mainers whose communities are impacted by state dollars continuing to be poured into policing and incarceration instead of our futures. Our campaign is driven by the leadership of currently and formerly incarcerated youth, the experts about how we build strong communities and end the harms of incarceration. We deeply thank Representative Brennan for his commitment for closing Long Creek and for spearheading the Juvenile Justice Task Force. And as task force members will remember, we were there at every public hearing and public forum that the task force did to name the isolation, violence, and traumatization that people were experiencing inside the Department of Corrections. That is why I am here today to urge this committee to vote ought not to pass on this legislation as it currently stands. For too long, young people in Long Creek we've seen Long Creek been used as a tool to control and harm young people. It's taken away young people's liberties, their freedom, and their access to their communities. And all you have to do is look at the ongoing deaths inside Long Creek and outside of Long Creek when young people leave the facility. And we saw in the Center for Children's Law and Policy report in February 2020 that they recommended Maine take steps to remove all young people from Long Creek and assign responsibility of youth to a new agency. This legislation is pointing to the roots of the problem at hand, that we don't have investment into residential programs for youth, into mental health care, into housing. But we do weirdly have $600,000 a year per young person in Long Creek to incarcerate them. Formerly incarcerated young people in Maine have been telling this state and this legislative committee for years now that there is a solution. It's community reinvestment. And what that community reinvestment looks like is taking away funds from the Department of Corrections budget for juvenile services and investing it into the communities and organizations that have the expertise, skills, and relationships to care for young people. We know that the Department of Corrections is not the adequate agency to administer reinvestment funds. A Department of Justice report in 2018 showed that 9.1% of young people in Long Creek reported sexual victimization under the DOC's control. And we also know that the Department of Corrections had multiple COVID-19 outbreaks with their staff, including 12 Long Creek staffers this December. We recommend that this committee creates a grant-making intermediary to support community investment. But most importantly, we are asking this committee to listen to young people and create legislation with a plan for closure of Long Creek, a plan for reinvestment of the $18 million currently being used to incarcerate young people. And under no circumstances should there be movement on developing or building new secure facilities for young people. There needs to be a commitment and a plan for the closure of Long Creek. And I'm happy to take questions. Thank you all so much.
Thank you. Questions? Al, I have the same question that I asked Mr. Jackson, but I'll start it off with a saying that I try to remind myself of all the time. Nothing about us without us, right? So nothing about us without us means I need to always be thinking, am I making sure that in creating this policy, I'm including folks with lived experience? And your group is made up of folks that are both formally and currently justice involved. And I just have to say, you guys kind of live, eat, sleep, breathe, drink justice, reform. Were you consulted on the plan that was recently presented to us by the DOC?
Yeah, thank you so much for the question. Maine Youth Justice was not consulted about the plan by the Department of Corrections. In addition, Maine Youth Justice organizers and community members have been calling on the Department of Corrections for answers about COVID safety and precautions for young people and staff in Long Creek for over a year now, and we have received no response. We think that's really concerning, and we really ask this committee to talk about what the ongoing risks for young people are in Long Creek after a year of isolation in the pandemic.
Thank you for that. When DOC was with us, I asked the commissioner to please reach out to you all and get your perspective, because I think that's really important for us as we proceed. Has that happened? That was a couple weeks ago. Thank you. I'll circle back. We will be really stymied. At least my participation will be until we make sure that everybody involved is being heard in the process. Thank you for that. Let me look at my list. We have questions, and I have Representative Costain, followed by Representative Morales.
Thank you, Madam Chair. Thank you, Ms. Cleaves, for being here. Question for you. So if you feel that no juveniles should be in facilities, what would we do with juveniles that say murder somebody or are not safe to be out because of the hazard to non-safety to the public? What's your suggestion there?
Thanks for the question. In the Center for Children's Law and Policy report, you can look and get a breakdown about all the reasons that young people might be detained in Long Creek. And what I think is really important to name is why young people are in Long Creek, and it's because the state is failing them, that the state is failing to provide the resources, the support, and the care that young people need to thrive, and that is our responsibility. And when the state is failing to provide the support that young people need, that's when we need to step up, examine our current actions, and figure out what needs to change. Currently, our response is to incarcerate young people when they cause harm. Our response is not to ask what is happening to this young person, what has happened in this young person's life, and what do they need. We are saying that there are only 28 young people in Long Creek, and with $18 million that we can invest in teams of people that have the experience to ask those questions and provide the support to those young people. We also believe that 28 young people should be wrapped around in their communities and not sent to isolation and then to get traumatized and harmed, to continue and try to figure out how to heal from that without any resources or support from the people around them in their neighborhoods.
Thank you.
Representative Morales.
Thank you so much for your testimony. My question is around the concerns that you have with having a DOC approach with corrections officers staffing steps for girls and Bering's House for boys, which was a part of their plan in their proposal, but I think they are already operating that. And I'm not quite sure if that's true or not, but what is your concern around that?
I think what we're continuing to see is that the Department of Corrections has been named by experts and by young people as not the appropriate agency to care for young people. Maine is one of the very handful of states that have young people at all under the jurisdiction of the Department of Corrections. For the Department of Corrections to move young people from some staff to just changing the location and continuing staff doesn't feel like we're changing any of the administration and any of the real roots of why young people shouldn't be under the DOC's control. So I think I'll just conclude with naming that, to me, that doesn't seem like a changing of Long Creek. It just seems like just shifting buildings, which isn't ending youth incarceration. And I would continue to ask questions about why those young people were under the jurisdiction of DHHS or other state agencies, and what type of services that they might be lacking under DOC that they'd be getting somewhere else.
Thank you.
Any other questions for Al Cleveland? Seeing none, thank you. Next up, I have Sky Goslin. Welcome, Sky.
Hello, Representative Warren and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Sky Goslin, and I'm a community organizer with Maine Youth Justice. Thank you for the opportunity to testify today. So Maine Youth Justice is a nonpartisan campaign fighting to end youth incarceration in Maine and invest in a range of community-based supports that respond to young people's needs, support families, and build community. We are a campaign led by young people who have been incarcerated in Long Creek and directly impacted by the juvenile justice system. We are calling for the closure of Long Creek Youth Development Center, the end of youth incarceration, and the reinvestment of $18.6 million currently being spent to lock up Maine's youth. Maine Youth Justice is opposed to this bill as it is currently written. We thank Representative Brennan for his commitment to close Long Creek and encourage his committee to take all actions to get there. As this bill stands, it does not call for the closure of Long Creek or the decarceration of the 26 youth still inside the last youth prison. Any efforts to end youth incarceration and build out the continuum of care Maine needs to include leadership and expertise of formerly incarcerated people. Maine Youth Justice believes that no young person should be incarcerated or prosecuted in the criminal legal system. This summer, thousands of Mainers protested in solidarity with Black lives, demanding the closure of Long Creek Youth Development Center. I was 14 the first time I went to Long Creek. Before I was locked up, my friends were all sent there. I was lonely on the outside and lonely on the inside. I never should have been incarcerated so young. My relationship with education was harmed when I was arrested at school. Being ripped from my school and community to get sent to Long Creek left trauma around education. 7 years later, I'm healing my relationship with education, but not because of Long Creek supporting my growth. but because of my commitment to make sure no young people have to go through the experiences that I did. What I needed instead of Long Creek was someone to have just helped me that first day, someone who believed my side of the story before jumping to conclusions. I was impacted by the juvenile justice system before I was arrested. I was targeted by my school resource officer and was navigating a community without resources or programming to support me and my family's needs. Most kids just need to feel cared for, not just another case with numbers at the top. Many people do not understand the kind of trauma young people experience while incarcerated. While young people are incarcerated, we begin to see ourselves as society treats us, as outcasts driving us further into a life of troublemaking. The trauma does not stop once you leave detention. Your family and friends have all moved on. There's no catching up on your education, and the state provides little resources to stop the acclimation. Young people leave incarcerated settings so traumatized that they lost an understanding of human interaction, including how you handle conflict or connect with people. There is no going back to how it was before incarceration, and we as young people are stuck dealing with the pain that was forced upon us in a failed attempt at justice. LD 546 appropriates $2.2 million additional funds to the Department of Corrections. MDOC is not the appropriate agency to administer community reinvestment funds or to oversee the creation of new community-based programs for youth and family. Can I get like an extra 10 seconds to finish it? Cool, thank you. Young people and their families do not have confidence that MDOC will keep them safe. For too long, we have been under the control and the fear of Department of Corrections. Youth don't belong to be under correctional control. We need care and support, and without fear of incarceration and isolation. So again, Maine Youth Justice encourages this committee to listen to the communities most impacted by the harms of youth incarceration. We have the answers, and it begins with the plan to end the criminalization of youth and investment into care, support, and resources for young people and their families that is led by the community, not by the Department of Corrections. Thank you.
Thank you, Ms. Goslin. It is not easy to come and share your personal experiences. You have a lot of courage. I think you're amazing. Thank you.
Thank you.
Questions for Ms. Goslin? Seeing none. Thank you. Oh, excuse me, Representative Pickett. Oops, you might still be on mute.
Thank you very much, Ms. Goslin, for being here and for your testimony. I appreciate it very much. I just have one question because I want to be 100% clear on what you're saying here. And one point that I want to really be clear on is your organization, or at least the organization you're speaking for, you're saying that your goal is to have no youth incarcerated. So you're against incarcerating youth. Am I correct?
Yes.
Okay, thank you.
Thank you. All right. Thank you for the opportunity to testify today.
Thank you. Seeing no more questions, we'll move on to Tina Nedow, who's here to testify in opposition. Welcome.
Good afternoon. Thank you, Representative Warren. My name is Tina Nedow. I am the Executive Director of the Maine Association of Criminal Defense Lawyers. Of course, based on just our position on everything, we support proposals that divert children away from the system, away from incarceration, and away from further traumatization. Unfortunately, this is not the bill that does that. And because of that, we cannot support this bill as it's currently written. There is one section that no one else has really discussed, and that is Section 1, that we do believe deserves full support. And that is to eliminate the consideration that because we have, quote, no other place to put a child, that we're going to detain them at Long Creek. That needs to go away. That never should have been the case. We don't do that for adults. We certainly should not do that for children. And I would strongly encourage this committee to take that up and pass it as recommended. Perhaps it's a bit of sour grapes right now, but I've also been closely following the legislature's very contentious budget process over the past few months. And so I'm kind of obsessed with numbers right now. And I've included in my testimony the breakdown for Long Creek, which I know you have all looked at very closely, the breakdown for community corrections for juveniles, which is also part of the DOC, as well as the Maine Commission on Indigent Legal Services budget. As you see, the number for Long Creek goes up every single year. The population of Long Creek has been reduced by more than 75% since 2010, and the budget has gone up and up and up. So any proposal that doesn't take away money from the DOC, but in fact proposes to give it more or not reduce the total budget to an amount that actually makes sense, doesn't meet muster. So even the DOC's proposal, which apparently they didn't actually consult anyone on the ground about who would actually be impacted by this, even that proposal, by reducing by 6 million, we get to $400,000 per child incarcerated at Long Creek as opposed to 600,000. Name me a single other budget in this state where we support such madness in spending. Not only is it destructive, it's wasteful. So again, this is not the bill that gets us to where we need to be. It still encourages a massive amount of spending towards the incarceration of children with no end date in sight. So for those reasons, Maxwell opposes it and we join with the other opposition.
Thank you. Any questions? Seeing none, thank you for your testimony. That was what I have on my list for folks in opposition, but I believe I made a mistake and missed somebody in support. So I'm going to go back around. Anyone here to testify in support of the bill, please raise your hand. And you have to raise your hand electronically or I can't see you.
That individual is no longer in the waiting room.
Okay. Okay, well, I apologize for that. So seeing no more testimony then, I'm correct about that, Deb?
Yes.
Thank you. Seeing no more testimony, I will close the public hearing on.
Neither?
I'm sorry. Thank you. I will now take testimony for the position neither for nor against. And if you're here to testify neither for nor against, please raise your hand. Seeing none, I will now close the public hearing for LD 546. Thank you all for being here and thank you committee members. Our next meeting is Monday at 10. Jane, do you have anything for us? No. Okay. Committee members, all good? Anybody need anything from Jane about these 3 public hearings before the work session? Feel free to ask now or to let Jane know.
Madam Chair.
Yes, please.
So by looking at the schedule for next week, then we are only going to be meeting in committee for work sessions on Monday. And then we have a House and Senate session on Tuesday. And then the doors close and we don't know when we're going to be back again. Is that correct?
That's correct. We didn't schedule anything on Friday because it's Good Friday and we wanted to be respectful, obviously, of that. So we will be back on the following Monday. We have scheduled Monday the 5th. We've scheduled Wednesday the 7th. We've scheduled Friday the 9th. But we wanted to be respectful of Good Friday.
So Wednesday after the session, we're expecting a long night, so we probably need some sleep that day, right?
Yes, we did not schedule, as we saw the other day when we didn't leave until 2 in the morning, we didn't want you guys to have to be here if that happens. We won't be doing anybody any favors by not getting our rest, so.
Okay, thank you, Madam Chair.
You're very welcome. Great, everyone. Well, I hope you have a wonderful weekend and we'll see you next week. Thank you, Jane and Deb.